I rise today to speak about an important form of intellectual property trade success. I'm pleased to be participating in this colloquy with my friend from Delaware, Senator Chris Coons. Earlier this year, we introduced the Defend Trade Secrets Act, a bill that will create a harmonized, uniform federal standard for protecting trade secrets. Trade secrets such as customer lists, formulas, and manufacturing processes are an essential form of intellectual property. Yet trade secrets are the only form of U.S. intellectual property where misuse does not provide the owner with a federal private right of action. Instead, trade secret owners must rely on state courts or federal prosecutors to protect their rights. The multi-state procedural and jurisdictional issues that arise in such cases are costly and complicated, and the Department of Justice lacks the resources to prosecute many trade secret cases. These systemic issues put companies at a great disadvantage since the victims of trade secret theft need to recover information quickly before it crosses state lines or leaves the country. At a time when cyber theft of trade secrets is at an all-time high, particularly as it involves Chinese competitors, it is critically important that U.S. companies have the ability to protect their trade secrets in federal court. Senator Coons, trade secret theft has hit some of the nation's best-known companies, including Delaware-based DuPont and its popular Kevlar synthetic fiber products. I'd just like to ask you, Senator Coons, how has trade secret theft impacted DuPont?
Well, thank you, Senator Hatch. Thank you for your leadership on this important issue. As the senator from Utah has mentioned, trade secrets are the only form of intellectual property not protected from theft under federal civil law, which is particularly striking when you consider the value of trade secrets to the economy. According to some estimates, they're worth $5 trillion to the U.S. economy, on par with IP protected by patents. And the scope of the loss due to theft or misappropriation is huge, somewhere between $160 and $480 billion annually. So I'd submit that there's not a state in the country that hasn't been affected by this problem, and Delaware is no exception. In the 1960s, DuPont, one of our signature manufacturing chemistry-based companies, invented Kevlar, a polyaramid fiber with extraordinary strength that's also very lightweight. And these properties make Kevlar versatile, but its best-known use is in life-saving body armor worn by our police officers and the brave men and women in the American Armed Forces. It saved thousands of lives, including more than 3,000 police officers here in the United States whose lives have been saved by Kevlar vests. About 10 years ago, DuPont developed the next generation of Kevlar, which is even lighter and better able to withstand penetrating trauma from a broader range of rifle rounds and IED-generated shrapnel. Represented a real breakthrough in safety, but it cost millions and millions of dollars to develop. You see, chemically, polyaramid fibers are really not that complicated, but the fabrication method, the manufacturing techniques, which is what gives them their strength and flexibility, is actually incredibly difficult to develop and implement. So one day, about 6 years ago, a rogue employee of DuPont took the know-how behind DuPont's creation of next-generation Kevlar and began work with a rival manufacturing company in Korea using DuPont's trade secrets. The potential loss to DuPont alone from this one instance of trade secret theft or misappropriation approaches $1 billion US. So, Senator Hatch, I'd ask you, if you were a CEO and your employees were ripping off your trade secrets, your intellectual property, and taking it to another country at the cost of $1 billion a pop, would that affect your willingness to invest the resources in future R&D here in the United States that are needed to make similar life-saving technological breakthroughs?
Well, of course it would. And thank you, Senator Coons. You've asked what really is the critical question. If I were a CEO responsible to my shareholders, I could not, according to my fiduciary duties, make those investments if rogue employees could just take off and render those investments worthless. And trade secret theft doesn't just affect manufacturing. I read recently an interesting article in the New Republic titled Corn Wars that provides a detailed account of how China is stealing proprietary corn seeds from America's farms. Most corn in China is used as a feed for livestock. That was not a problem until the country's middle class acquired an appetite for meat. Given this new demand, China is trying desperately to increase corn production amid its water shortage and lack of arable land. That's where our country's intellectual property comes in. Rather than spend the time and resources to develop a hybrid corn seed of its own, China would rather steal, literally right out of the ground, America's high-performing seeds. Experts from America's top seed producers confirm that acquiring the technology behind a specially designed line of seed is equivalent to 5 to 8 years of research and at least $40 million. And you better believe the Chinese know the value of the seeds they steal and the numerous crimes they are committing while in our country. Let me read an excerpt from the New Republic article that details an encounter a DuPont Pioneer field manager had with industrial spies from a Chinese agricultural company. Quote, "It was early May 2011, and Mo Heilong and Wang Li, vice chairman of King's Nauer Seed at the time, were driving roads in Tama County, Iowa, allegedly searching for a DuPont Pioneer test field. But apparently uncertain if he was in the right place or unsure of what kind of seed DuPont Pioneer was testing, Mo had Wang pulled to the edge of the field so they could question a farmer in the midst of spring planting. How had these two men chanced upon his field on the very day that he happened to be planting an experimental and top-secret seed under development by DuPont Pioneer? The next day, a DuPont Pioneer field manager spotted the same car. He watched Mo scramble up a ditch bank and then kneel down in the dirt and begin digging corn seeds out of the ground. When confronted by the field manager, Mo grew flustered and red-faced, but before the field manager could question him any further, Mo fled," unquote. There is no doubt that China and other foreign competitors are working furiously to steal American innovation, not just for manufacturing and agriculture, but for all sectors of the economy, including high-tech, life sciences, aeronautics, financial services, and the energy sector. That is why Congress must act now to pass the bipartisan bicameral Defend Trade Secrets Act. Now, Senator Coons, what exactly does this bill that you and I are co-sponsoring do?
Thank you, Senator Hatch, for the opportunity to go into more detail about this terrific bipartisan bicameral Defend Trade Secrets Act. It's actually relatively simple. It creates a federal private right of action for misappropriation of trade secrets. It uses an existing federal criminal law, the Economic Espionage Act, to define trade secrets, and it draws heavily from the Uniform Trade Secrets Act, which has been enacted by many states, to define what is misappropriation. Simply put, our bill harmonizes U.S. law. Each state has a different trade secret law, and they vary in a range of different ways. And not all of these differences are major, but they affect in small but real ways the definition of a trade secret, what an owner must do to keep a trade secret a secret, what constitutes misappropriation, and what damages are available. So our Defend Trade Secrets Act creates a single national baseline or a minimum level of protection and gives trade secret owners access to both a uniform national law and our excellent federal courts, which provide nationwide service of process and execution of judgments. It's important to note that this bill doesn't preempt state law because states are free to add further protections on top of what's in this bill. The proposed legislation does one more thing, and trade secret owners tell us this is a critical component of the law not available in states. It creates an ex parte seizure ability. You see, trade secrets are different from other forms of intellectual property because they're protected under the law only if they remain a secret. Once the public learns of a trade secret, even if it does so wrongfully, the trade secret loses its legal protection. So this bill provides a limited right of action for the owner of a trade secret to go to court ex parte and get it back before the misappropriator, the thief of the trade secret, has a chance to share it with a competitor or the world, thus exposing it. This really is a common sense idea to help address a very serious problem. But when you talk about federal private rights of action and ex parte injunctive relief, we had to be very careful to avoid any unintended consequences. So, Senator Hatch, would you address how you took concerns about unintended consequences into account as we work together to draft this bill?
Sure. I want to thank you, Senator Coons, for that helpful overview. As a Republican, I was initially cautious when you approached me about expanding federal civil law to create a new private right of action for trade secret theft. After all, some have suggested that state law is sufficient. But after consulting with many in the business community, I was convinced that creating a federal trade secrets law is the right approach. Soon after introduction, the Heritage Foundation confirmed the need for federal legislation. Mr. Alden Abbott from the Heritage Foundation writes, quote, "The lack of a federal civil remedy for victims of trade secret theft precludes owners of trade secrets from vindicating their rights under certain circumstances. Enjoining and sanctioning trade secret thieves who cross state lines is often difficult. A federal civil statutory remedy would make federal tribunals instantly available to aggrieved businesses that seek injunctions, which is particularly important when time is of the essence due to flight risks," unquote. Another problem that we faced was ensuring that the ex parte seizure authority could not be used abusively or for anti-competitive purposes. When we began the drafting process last Congress, we started from scratch and asked for input from all interested stakeholders, especially in regard to the ex parte provision. We received many helpful suggestions and included them in the bill. That's correct, isn't it, Senator Coons?
Yes, it is, Senator Hatch. And after all that work together, all that consultation, when we introduced this bill last Congress, we wanted to make sure that the ex parte provision couldn't be used for abuse, so we required that the party seeking ex parte review must make a rigorous showing that they owned the trade secret, that the trade secret had been stolen, and that third parties would not be harmed if an ex parte order were granted. We also included damages for wrongful seizure, including attorney's fees. And with that whole combination of, I think, important measures to ensure that the ex parte seizure capabilities under the statute are not misused, I think we achieved real consensus at that time. Isn't that right, Senator Hatch?
That is right, Senator Coons. And as we prepared to reintroduce our bill at this Congress, we were fortunate to join forces with Senator Jeff Flake of Arizona. He was invaluable in fine-tuning the ex parte seizure language. Because of Senator Flake's good work, I believe the ex parte provisions are where they need to be: strong, fair, and not susceptible to abuse. Would you agree with that?
Yes, I would. Thanks in no small part to you, Senator Hatch, and to Senator Flake, who insisted both last Congress and this Congress that we put everything on the table and invite all stakeholders to come forward and share their concerns. We worked together, we did that, and we found an incredible consensus. In addition to talking with industry, we've gone to think tanks and academic institutions about this bill. Some people that we've spoken to raised concerns that our bill as previously drafted could harm employee mobility. So, Senator Hatch, I don't want to restrict employee mobility, and I don't think you want to either. Is that right?
Well, that's right, Senator Coons. I never thought our bill harmed employee liability, or mobility, excuse me. But when I heard these concerns, I wanted to make sure that we addressed this particular issue. So we included language in the bill this Congress that states explicitly that a person cannot be prevented from accepting an offer of employment because of his or her prior exposure to trade secrets. I think we've struck the right balance with this bill. I'm not aware of any stakeholder opposition to this bill. Those who operate businesses in the real world and have to protect their trade secrets on a regular basis are strong supporters of the Defend Trade Secrets Act. The list of companies and associations that have endorsed the act is diverse and impressive. Let me read the names of some of the businesses and organizations that support this bill: Adobe, AdvaMed, American Bar Association, Section of Intellectual Property Law, American Intellectual Property Law Association, Association of Global Automakers, Inc., Biotechnology Industry Organization, the Boeing Company, Boston Scientific, BSA, the Software Alliance, Caterpillar, Corning Incorporated, DuPont, Eli Lilly and Company, General Electric, Honda, IBM, Illinois Tool Works, Inc., Information Technology Industry Council, Intel, International Fragrance Association of North America, Johnson & Johnson, Medical Device Manufacturers Association, Medtronic, Michelin North America, Micron, Microsoft, National Alliance for Jobs and Innovation, National Association of Manufacturers, the New England Council, Nike, Pfizer, Philips, the Intellectual Property Owners Association, the Procter & Gamble Company, the Semiconductor Industry Association, SAS, Software and Information Industry Association, the U.S. Chamber of Commerce, United Technologies Corporation, and let me just mention one more. There are others, but 3M. Mr. President, I ask unanimous consent that letters of support from these organizations be inserted into the congressional record at this point.
Without objection, so ordered.
Thank you. Senator Coons, don't you think it's time that Congress acted on trade secret theft?
Absolutely, Senator Hatch, I do. I think when you talk about an important issue like trade secret theft, which poses such a great threat to American innovation and economic growth and our competitiveness, it really is past time that we act on this issue. And this bill is truly bipartisan. I was the lead sponsor in the last Congress. You are the lead sponsor in this Congress. And along the way, we've worked closely together and undertaken an inclusive and iterative process to make sure we've heard from all stakeholder perspectives so that we have legislation that creates winners only, not winners and losers. And Senator Hatch, it's been an honor to work with you on this. You have been a big part of the reason we're able to undertake such a successful and constructive process. And I'd ask you, Senator Hatch, in your view, has this process now produced a bill that's ready to move in the Senate Judiciary Committee on which we both serve?
Well, first of all, I just want to thank you for your work on this, Senator Coons. You have been a great partner in advancing this bill. And I agree with you that the Defend Trade Secrets Act is ready to move, not just through the Senate Judiciary Committee, but also on the Senate floor. In fact, I think this is the type of a bill that could move by unanimous consent. At the same time, we're not closing the door or turning a deaf ear to anyone who has thoughts on this legislation. Let me say this. If any of my colleagues has concerns or questions about the bill, come talk to me or Senator Coons. Now's the time to resolve your concerns, and we'll resolve them. If you talk to any of the companies that were initially on the fringes but are now supporters of the bill, I think they will agree that you and I are willing to address all legitimate concerns. So work with us. I'm pleased with the momentum we have already seen on this bill through industry support and here in the Senate. One way that is happening is senators on both sides of the aisle want to support this bill. To that end, Mr. President, I ask unanimous consent that Senators James Risch, Mike Crapo, and Roy Blunt be added as co-sponsors to the Defend Trade Secrets Act, S. 1890.
Without objection.
I'm pleased with the support we've already seen and encourage many more of my colleagues to support and help us pass this bill. Help us make this happen. It's the right thing to do, and I yield the floor.